Good morning and welcome to VetNet Veteran Network brought to you by IBMF. My name is Elvis Avdic, and today we have with us our guest speaker Corey Michael Cal and our supporter here Ashley Squirrels at IBMF Alumni Manager. Before I kick it off, today's session is on avoiding litigation from employee-based lawsuits. So it's really good, important to know if you're an entrepreneur, once you establish your business, to make sure you put some ethics in there so you can avoid lawsuits from your employees. But if you're working for an employer, it's also good to see what is the proper way the employer should treat you. I'm going to pass now Mike to Corey and have him introduce himself and kick off the presentation.
Great. Thank you, Elvis, so much for having me here. And I just want to say to everyone watching that it's a big honor to be here at the IVMF, which is actually situated in my old law school, which is great, and just very happy to be back. So today we're going to talk about, as I set this up, basically protecting your small business from employment-based lawsuits or employee-based lawsuits, which is a huge issue, and it's something that you really need to be very concerned about and take the correct protective measures, the correct steps to make sure that you are safe. Now, we all hopefully like our employees and work with them, and they're part of a valued team, but it's very important not to ignore this important step in protecting your small business. So it's just a little bit of an overview of what we're going to talk about today. One is workplace conduct and sexual harassment, which is a huge area of liability that has to be protected for. And the second part is discrimination. And then we're going to, which is also another huge area, very, very important throughout the whole cycle, from hiring and interviewing to having employees and dismissing employees, et cetera. So that's a very important part. Hopefully you guys will stay tuned for that. Also, proprietary information and conflicts of interest. So a little bit about myself as your guide through this presentation. My name is Corey Michael Calley. I'm currently a legal advisor to the Syrian American Medical Society and the former general counsel to DevTech Systems. These are both international organizations. I've had the pleasure and the honor of working across the table from a lot of very large companies, ranging from cooperative, working on contracts and teaming agreements, to yelling and screaming and all kinds of crazy stuff. So I've had to run the whole gamut of contractual experience here, and I'm happy to help small businesses avoid some of the wide variety of pitfalls that are out there. I'm also would like to add that I'm a former contractor with USAID and also with Department of State. I've had the opportunity to work across a wide array of bureaus with the State Department. And I also have a lot of experience as a grant proposal writer as well. So moving on, before we begin, one of the things that you're going to want to do is ensure full compliance with federal and state labor and employment laws and ensure fair labor practices. Now, again, this presentation is not necessarily a deep dive into all of the legal and legislation surrounding all of these areas, although I'm going to touch on all of that. But that is a little bit beyond the scope of all of the things that we're going to talk about. Again, this is a general presentation. There's a lot of great information here, but one of the things you're going to want to do is a self-assessment and make sure that you are in compliance with your federal and state labor laws. Okay, and if I'm going to have my contact information here, if you need help with that, I'm happy to field questions, and also you can contact me separately after this presentation. Okay, so we're going to start with workplace conduct and sexual harassment. And the bird's eye view on this is basically we want to set up a fair and equitable working environment. This is going to prevent an enormous amount of bad feelings with your employees and also help reduce the probability of a lawsuit, employee-based lawsuit. Okay, so your responsibility as a small business owner is to foster a safe and respectful work environment for all of your employees. Now, your staff have responsibilities as well. And one of the things I'm going to advocate very strongly for, and I think it's a very wise decision to implement this in your small business, is developing a formal code of conduct. All right, because your staff themselves should be preventing, reporting, and abstaining from inappropriate behavior like sexual discrimination, bullying, workplace violence. And one of the things that's going to help facilitate that is to ensure that your staff knows the company code of conduct and that they practice sound judgment, right? So a lot of this is just common sense and common courtesy, but in a lot of work environments, those things over time start to fall by the wayside. It's important to have this formally commemorated in a code of conduct, which you may or may not have. They're not that hard to put together. And again, I'm happy to field questions if you have technical questions about how to do this later. You have my contact information on these slides, okay? So it's a best practice. We want a clear and comprehensive company code of conduct, right? This should be signed and dated by the owner, the CEO, the director, whoever the top of the food chain is there at your small business. Now, it's important that I have a little note here. Company culture is always set by the top person. It is always set by the top person. So if you yourself are disrespectful to coworkers, and you're making lewd jokes, and you're doing these kind of things, you're setting yourself up for problems in the future, because they will mimic and copy your behavior over time. It's important to consider that. Now, regarding the code of conduct, you want a code of conduct that is circulated and signed and dated by all of the staff. Now, this is very important, because not only does it get buy-in and create a collective experience for your staff, but also, very importantly, you are creating a paper trail in the event that litigation does in fact occur, and you have some kind of a suit, or there's some kind of an issue. If you have to stand before a judge, you're going to want a file with a lot of paperwork in it, demonstrating that you have instituted best practices and that you have done everything within your ability to ensure an ethical and fair workplace environment that follows the rules. Okay. Now, one of the other things I want to add on here is that you should be having an annual meeting with your work staff. Now, you may have a huge staff of employees. You may have a small staff of 4 or 5 people. It really doesn't matter, but you should have a formal meeting every year. There should be meeting minutes kept. And during this meeting, you should be doing annual trainings. That's ethics trainings, that's sexual harassment trainings, that's reviewing the code of conduct, which is here. But there's a whole suite of things that you can put together for this annual meeting that will check the box annually with all of your employees, and make a very big difference in the event that you, again, have to defend against a lawsuit. Okay. Now, code of conduct. The code of conduct is your company policy. It is designed to support day-to-day decision-making, and it determines appropriate and inappropriate behavior. Okay. It should also set out your company's mission, your company's values, and your core principles. Okay. It also commits management to compliance and applicable laws, and it should be used for reference when there are questions as to appropriateness of conduct on behavior or ethical dilemmas. Again, some of the types of behavior will be in gray areas, and this is where the code of conduct can certainly help you a lot. Okay. Remember, we can't anticipate every issue, but there's a kind of a general rule of thumb. If something seems off, unethical, or improper, it probably is. Okay. As the owners and the staff, obviously, you should read and understand the code of conduct. And also, owners and managers need to be aware of specific rules surrounding their own staff and employees. This is important. Okay. We want to talk a little bit now about workplace misconduct. Okay, this is where we're going to get into stuff, and this is the wide range of things that you will see in the workplace. Now, I'm going to move quickly through these slides because I want to leave room at the end for questions. But we can certainly follow up on any of these if I move too quickly. Okay. So recognizing harassment in the workplace. Okay. So there's a whole bunch of things that hit the mark for what is harassment that you need to be concerned about, and especially in sometimes kind of informal or relaxed workplace atmospheres. It's great to have that kind of atmosphere, but it also can lead to unprofessional behavior, which at a certain point you hit kind of you cross a threshold and you have liability. We want to avoid that. Okay. So stereotyped and demeaning remarks or gestures by staff from one to another, sexual harassment, workplace bullying. We're going to unpack those shortly. One of the things that you see often is display or circulation of offensive materials or pictures that are offensive. These could be emails or funny things that are circulated that can, hit a wide range of sensitive issues: racial, religious, creed, color, citizenship, national origin, age discrimination. We're going to talk about that shortly. Sex, gender, identity expression, sexual orientation, marital status, disability, genetic information, veteran status, or any other legally protected basis in accordance with federal, state, or local laws. Again, we want to honor all of these protected statuses and make sure that we reduce probability for lawsuits as a result. Okay. When harassment becomes actionable. Okay. So there is a range of joking around or interacting, if you will, with your coworkers that is not actionable. There's not really a lawsuit there. But there's a certain level, it rises to a certain level where someone could have a legitimate claim. Okay. And basically what we're looking at, the kind of behavior violating one of those aforementioned categories that is severe or pervasive. That's one. Two would be that it alters employment conditions. So what does that mean? That might mean that someone has to come to work later or shows up late intentionally to avoid some kind of interaction with an employee, or has to have a certain remote work day because they can't work with someone. These are red flags. You should be looking for these red flags, okay? You need to take this stuff very seriously, all right? Now, create any kind of behavior, thirdly, that creates an abusive working environment, okay? You have to be on the lookout for these, especially these three core phenomenon that you want to make sure will avoid harassment becoming actionable. Now, we talked so much about sexual harassment, and we're going to do a deep dive into it shortly, but harassment does not need to be sexual in nature. It can just be offensive marks, and it can be simple teasing or offhanded comments that can be viewed as creating a hostile work environment, and that's actually a legal term. We're going to get into that shortly. All right. Humor and harassment. Now, this is a big area. I mean, a lot of people, myself included, we like to have a good rapport with their coworkers. We like to joke around, but there's a limit to this, right? So the big thing is your perception, the perception of jokes. So if employees are finding these to be offensive, if your coworkers are offended by someone's humor or inappropriate joking, it could be considered harassment. And again, it's the perception of the offended parties, the party that matters. So you can say something innocently, or you can have someone in your staff making a joke, a political joke, or some kind of a joke that is really just for good fun and they don't mean anything. Someone there that is offended by that is really, that's really the measure that the courts are going to look at, right? So you have to keep that in mind. One of the big areas of this, of course, is emails, and people email each other all the time in a work environment. You have to be very careful, and that would be something that you'd want to include in your code of conduct, okay? So the key points here is employees shouldn't use company email accounts to send risky jokes to their colleagues, and you just have to be just generally careful about this, okay? Now, I'm moving quickly here, but I want to make sure that I leave time at the end because I know we have about an hour here. Sexual harassment is a huge area, okay? You have to be very careful about this area. Let's define sexual harassment here. Sexual harassment is the unwelcome sexual advances, requests for sexual favors, and or other verbal or physical conduct of a sexual nature. So submission to such conduct is made either implicit or explicit as a term or condition of employment. That's obviously a huge red zone. You have, that's an automatic sexual harassment lawsuit right there. You never want to have that, first and foremost. Hopefully all of the people watching this, no one has this issue, okay? If you do, you've got to correct it immediately. So the second one is submission or rejection of such a conduct would be used as a basis for employment decisions, okay? And we're going to talk about quid pro quo and hostile work environment in the next slide. But there can't be anything going on a date or any of this kind of stuff tied to anything related to employment-based decisions, okay? Again, that's a red line you cannot cross. All right, now, there are two main categories of sexual harassment. And, you know, it's interesting because I was recently at a big meeting with a large government employer, and they were talking about sexual harassment for about 2 hours, and they only mentioned quid pro quo, and they never mentioned the second and equally important and dangerous category, which is the hostile work environment. So going into them first, quid pro quo is defined as promising or denying something in exchange for favors. Supervisors rely on apparent or actual authority to extort sexual considerations from a subordinate, okay? This is what you commonly think of when you think of sexual harassment. The other one that is often forgotten about, but can cost you just as much money, and we're talking big numbers here, is the unwelcome conduct that interferes with an individual or group's ability to do his or her job. And again, it's the reasonable person standard applies to a hostile work environment claim, okay? Before I get into that, I want to talk a little bit more about hostile work environment, okay? Because I'm gonna go through this, but what is important to remember is someone needs to feel obviously unwelcomed or harassed in some way, and this can be just the general day-to-day business in the office, the joking that goes around in the presence of a third party in your office. It can be two people making lewd jokes, and a third person has to listen to it every day, and at a certain point, you have a hostile work environment lawsuit. So this is why, again, I'm circling back to the code of conduct, but this is why it's important, is that you have a formalized code of conduct that everyone signs off on and that is enforced, and it must be enforced, all right? Now, the dynamics of sexual harassment. there's a lot of things. I mean, we're just trying to get a little bit outside of the box here so that we understand that in the modern era, it's a little bit more dynamic, right? So harassment can be from the same sex. It can be sexual innuendos or just advances. It can be, it also qualifies with discrimination against a person on the basis of their gender or sex, okay? So again, it's not, maybe, there's a lot to this. We have to be very careful and unpack situations. Again, if you have questions, specific questions, feel free to email me or reach out, and I'm happy to talk with you, okay? Now, the victim does not have to be the person harassed, but could be anyone affected by the offensive conduct, which I just went into, okay? Unlawful sexual harassment may occur without economic injury or the discharge of the victim. So it doesn't have to result in a firing. It doesn't have to result in a demotion. It can just be the occurrence of the event. This is especially applicable with quid pro quo sexual harassment. Okay, remember, the conduct must be unwelcomed. I mean, obviously there's inter-office dating occurs. That's acceptable. That's not harassment. Harassment is unwelcomed. Okay, and after hours. Now, this is important. The sexual harassment rules can still apply between employees after hours. So if you're having an after hours cocktail party or something occurs, maybe you have a work group, they go out for drinks after work, that's fine, but there is still potential liability if you have someone harassing another person. So again, this is why the code of conduct helps, because it will train your employees to report this kind of behavior, not only in the workplace, but also outside of the workplace. So this is the kind of thing that you want to have in your code of conduct. Again, if you have questions or you need help with this, feel free to reach out to me. I'm happy to help you, okay? Now, examples of sexual harassment. Verbal harassment, which would be jokes, name calling, repeated requests for a date after a clear no from the requested party, whistling, cat calling, comments about a person's body, okay, descriptions of people. These are areas. Now, some of this is just normal behavior a little bit, talking about somebody in a workplace a little bit, but there is a red line, okay? Again, code of conduct helps define this for your staff, okay? Nonverbal visual harassment. So this is emails, texting, website links, blog posts, other social media, displaying suggestive objects, obscene notes, letters, or invitations, and also just leering at a person too much. I mean, if you get a complaint about someone in the office being leered at by another coworker, there needs to be, management needs to make an action, certainly put a note in file that has been, complaint has been received, and something needs to be discussed with that individual, because that, again, can also be a kind of harassment that may be actionable, okay? Obviously, there's physical harassment, teasing, offhand comments, and then, again, after hours is something that you still have to be concerned about, okay? Now, there are remedial measures that management can take for sexual harassment. Training during your employees' onboarding, so when they're first hired, and at least once annually, again, circling back to the code of conduct and how this can help you and can be tied and married with the sexual harassment training, can be very helpful once a year. Assessing, obviously, senior management and hopefully your legal counsel that you have retained for your small business can take a look at what's going on at the outset of complaints, so that this is headed off as early as possible. Documenting. Now, this is a incredibly important aspect of protecting your small business. Okay, so all employee trainings, your personal files, and memos to files should be saved on each employee for each instance. The more documentation, the better. So for every single employee that you should have, your HR person, whoever's designated, maybe you have a formal HR officer, maybe it's informally done. Hopefully hopefully you have a formal HR officer, but there should be a file for each employee, okay? And especially if you start having issues with someone, there should be a papering of the files. Every incident is a memo to file, okay? And they don't need to see this. It shouldn't be something that they're even aware of, but there should be something in your internal files with your company where you're documenting each incident, and you're documenting management's response to each incident at the outset. Okay, this is going to help you tremendously in the event that you actually have a lawsuit. All right. Now, addressing. Now, here's the other thing. You also needed to take action. Okay, so there could be a dismissal in a severe case. In some of more of a minor incident, you might have a warning or a suspension. And then one of the things that is actually extremely helpful is to have a performance improvement plan, or a PIP. We've used this a lot in the past. They really work. And the idea is basically, if you have someone that is a repeat offender And certainly with something like sexual harassment, you really can't have repeat offenses. It's too much danger. But you can just have other just general issues. So just to put this in the proper context, I want to talk about performance improvement plans for a moment here, just generally for problem employees. Okay, people come in, they're not doing the job, or what have you, or So if you have someone where you're really thinking about letting them go, one of the good steps that you can take before that is instituting a performance improvement plan, which is a formal document, and it's a formal process that needs to be instituted through HR for your company. And basically, in a sense, it is punitive. I mean, the idea is you want to find the areas of where the individual is weak or where the problems are, and try to design a plan for them to address those issues. And it should be something where it is basically up or out. They're going to take on this extra work. They're going to do extra trainings. And it could be a wide array of different things that because it's subjective to each individual with their problems. But it's usually a 1 or 2 month performance improvement plan, and then they either graduate or they don't. And if they don't, you dismiss them, and that's it. All right. If they can actually reform their behavior, then obviously all this stuff again goes in the file. But maybe the person has a true change of heart and actually starts becoming a productive and compliant employee. Okay. And then defending again. One of the aspects of defending the suit, potential lawsuit here, is basically it's the documentation, and then making sure that it is clear that management has taken been very reactive to every response. Okay. Now we want to talk a little bit about workplace bullying and abusive conduct. It's very, very common, especially in the white collar world. Especially if you work in law and some of these other areas, it's really almost the norm, right? So, but some people, take it the wrong way, and then all of a sudden you can have a lawsuit. So there's a limit to it. Again, the cultures of every company, it's different. I understand that, and that should be taken into account. So again, we're painting with a very broad brush here, but I want to give all of our watchers here a wide array of tools to help them address any kind of potential issue. And again, reach out to me. I'm happy to help you. Okay. So workplace bullying. Bullying is the creation of an abusive work environment, which occurs when the defendant acts with malice and subjects an employee to abusive conduct so severe that it causes tangible harm to the employee. And this is a legal concept began in the 80s. There's big legal gaps in it. All right. So the thing is, it's not an open and shut case, but one of the reasons I have this here in this presentation is because it triggers a whole bunch of other potential claims, such as intentional infliction of emotional distress, intentional interference with an employment relationship. So these are torts, right? And it can also just be a catch-all for discrimination. You're being bullied because of X, Y, and Z, protected status, your age, your gender, sexual orientation, etc. So you have to watch out for this. Now, again, corporate cultures are different, right? Workplace cultures are different. But you need to know that even though that there's not really strong laws around workplace bullying, it is a dangerous area to allow to go unchecked. All right. Please keep that in mind. So again, what are the remedial actions? Just like sexual harassment, it's a simple process. There's training, again, onboarding annually with their supervisor as well. Assessing, having management assess it, documenting paper to files, memos to files, okay, addressing performance improvement plans, warnings, dismissals in severe cases, and defending, which obviously you're going to talk with your inside counsel, your outside counsel about defense strategies if you get to the point where you actually have a real lawsuit based around it. Now, workplace violence. Okay, you should never, ever, ever tolerate for any reasons any kind of workplace violence. Okay, and it's not only just physical violence, but it's also the threat of violence. It can occur outside the workplace, and it can also include verbal abuse to physical assaults. And actually, there's examples of homicides out there as well. So it's very serious, and this is the kind of thing where if you have a singular event can easily trigger a dismissal, and it's something you should consider, okay, very seriously. I want to talk to you about social media as well. Social media is another area where you see now in the news people are getting in all kinds of trouble related to social media and with their employers. So again, circling back to the code of conduct, it's important to put out at the outset of employment and also in the code of conduct at your annual meeting that the employees know and understand and sign off on the fact that they are representing you and your company at all times. That includes on the internet, okay? So there should be a section on social media in your code of conduct, okay? And they should know, your staff should know that they will be held accountable for inappropriate public behavior online, such as discriminatory posts, racist posts, all kinds of stuff. So look, people can have fun on Facebook and all that stuff, but there's a limit that crosses the line, and they should know in writing that they will be held responsible for that. All right. Now we're on to part 2. Congratulations. I appreciate you having sat with me here for the first 26 minutes of this presentation. We are halfway through. I'm going to continue to move quickly, and I'm going to also continue to remind you that I'm available if you'd like to reach out to me. I'm happy to help you and discuss some issues or clarify slides after this presentation, okay? And we're going to leave a few minutes for questions afterwards. So we're going to talk about discrimination, proprietary and personal information, and conflicts of interest, okay? Discrimination, now this is super important. This is another, just like sexual harassment, you must be airtight on your discrimination, avoiding discrimination practices for your small business. Okay, let's take a look at a few examples here. An ex-Ford employee awarded $17 million in a discrimination case. I've got a handful of examples here. This is just from the last year, all right? So these are huge, huge settlements. Now, Ford's huge. I'm sure your company is probably not as large as Ford, but still a single discrimination suit, if it's successful, can destroy your company. So this is why it's so important to take this stuff very seriously and implement the right strategies right at the outset. Okay, here's another one. Chipotle employee awarded over $500,000 pregnancy discrimination lawsuit. Panda Express, $600,000 settlement claim because it discriminated against actually Arab American citizens in this instance. Okay, women at Nike suing over a pay discrimination. Class action lawsuit. That's not a good thing. Okay. Employee wins massive age discrimination lawsuit against Lockheed Martin. We're talking over a $51 million lawsuit. Okay. So please, if you do anything today, take this section very, very seriously for your business. All right. Now, what is discrimination? Discrimination refers to unequal or unfair treatment of an individual or group based on certain characteristics protected by federal and or state law. Okay. So I'm going to slow down just a little bit here. I've been moving quickly, but I want to make sure that I'm clear with some of the stuff, because this is very, very important. Okay. So first of all, we're talking about Title VII of the Civil Rights Act of 1964. Okay. This is the primary law prohibiting discrimination in the workplace. Okay. So employees have a legal, moral, and ethical responsibility to guard against inappropriate workplace conduct. Okay. And some of these protected areas that we're going to go into: physical disabilities, race, age, religion, sexual orientation, and gender identity. So you cannot allow, obviously, this in the workplace with management decisions and with hiring practices, which we'll discuss in a second, okay? State law, okay? New York State, the opportunity to obtain employment without discrimination because of age, race, creed, color, national origin, sexual orientation, military status, sex, marital status, or disability is hereby recognized as and declared to be a civil right in New York State, okay? This is serious stuff. We want to stay in compliance with federal and state laws at all times, okay? Enforcement. So, as you know, you may have, this is what we want to avoid, right? We want to avoid employees going to the EEOC, which is responsible for preventing a number of these discriminatory practices, okay? And they enforce a handful of federal anti-discrimination laws, which I have listed here. Disability, let's talk about disability for a moment here. Americans with Disability Act became law in 1990. Okay, so it's prohibits discrimination and harassment and ensures equal opportunity for people with disabilities in employment. A disabled person. So what is a disabled person? Because we have to have a technical definition here. It's an individual with mental or physical impairments that substantially limit one or more major life activities. 1 second here. So let's just unpack this for 1 second. So mental or physical impairment that substantially limits one or more life activities. So this could be a physical handicap. It could be something external. It could be something internal, maybe a digestive issue, for example. I mean, you have to be very careful with health when your employees make health-related requests, okay, and discern whether or not one of these rise to the level of a disability. It's very different The flu is not a disability. Someone with a recurring digestive issue or some other issue, a breathing issue, whatever, it doesn't have to. So what I'm basically trying to say, it's not always someone that is maybe unable to walk or has something like that. So again, this is something I can help unpack with you if you have an issue. So feel free to reach out to me on this. But you have to be very careful about disability discrimination. Okay. And this applies obviously to private employers with 15 or more employees, and it applies to everybody, but there are certain very specific employment provisions that we can get into here a little bit later. So let me talk about this for a second. This is kind of where I'm going with all this. With disability, one of the main things is hiring. Okay, so this is where a lot of people really run afoul of the law. Okay, you cannot exclude someone because of a disability with hiring. Applicants have a legally protected right to choose whether they will disclose a disability in an interview. So the big thing is you cannot ask someone at their interview whether or not they are disabled. Okay. But what you can do is you can ask them about the ability to perform essential job functions. So for example, let's say you're running a warehouse. You cannot ask a potential employee if they are disabled or have disabilities, but you can ask about the ability, for example, to lift boxes or to deal with a set of stairs, for example. So this is an area where you have to be very careful when you during the hiring process. Employee performance evaluations. Okay, so employers must use the same standards to measure performance. So your standards cannot be different for a disabled individual than they are for a full-bodied individual. Okay, now job standards, they must be related to essential as well as marginal functions of the job. Okay, essential functions are tasks, duties, and responsibilities that are fundamental. So employees must be able to perform these with or without reasonable accommodation. And the essential function is the completed task, not how it is performed. So for example, and we're going to talk about reasonable accommodation in a moment, you could have a disabled employee that has to use a different set of procedures to accomplish the same goal with a reasonable accommodation. So there may be something that would be, obviously help them. So the most obvious example of reasonable accommodation would be something like a wheelchair ramp. Okay, but it could be anything, frankly, as long as doesn't create an undue burden on the employer. It would be a reasonable accommodation. Okay, so that's the essential function prong. The other one is marginal functions, and that is one that is not essential to a specific job role. It could be performed by another person or made part of another job or another job role. So both of these areas, you got to make sure that when you're doing a performance evaluation, and this is especially important during times where you're looking at promoting people, etc., that there is no discrimination between your disabled employees and your non-disabled employees. Okay. So hiring. Okay, who is a qualified individual? Because again, you might be thinking right now, well, if somebody comes in, how would I know whether or not they're qualified? I can't ask them about the disability, and I've got all these other things I've got to think about during the hiring. So someone is a qualified individual who satisfies the requisite skill, experience, education, and other job-related requirements of the job, and who can perform the essential functions of a job with or without reasonable accommodation. So if someone cannot perform the essential functions of a job with reasonable accommodation, then they really wouldn't have a disability lawsuit, because you have constructed not only your hiring process, but also made opportunities for them to have the ability to perform essential job functions. Now, if they still can't do it, that's a whole separate thing, and obviously you can't hire people that are incompetent or unable to do the basic job. Okay, so this applies to both existing employees and prospective employees as well. Moving quickly here, but I want to make sure that we've got time for questions at the end. Sexual orientation and gender identity. This is another protected area that is it's very important as well. A person's inner sense of their own gender it's expressed. So we're talking about gender identity now. Expressed in dress, grooming, speech patterns, and other indicia. Be masculine or feminine, obviously, and it's unlawful to discriminate. Now, transgender discrimination. this is again another form of sexual discrimination. Okay, so really there are some gaps with some of the legislation surrounding transgender discrimination, but basically we have an equal protection issue potentially, and a whole bunch of other, again, some of these issues are nested, right? So you have an equal protection claim. It could also trigger intentional infliction of emotional distress and a whole bunch of other things. So again, if you are hiring a transgender individual, they should be treated equally and fairly along the lines of any other employee. Okay. Discrimination, sexual orientation, gender orientation, again, intent versus perception. Okay. So the individual is required to bring the claim to prove harassment or discrimination occurred. Employees who assert discrimination claims must show that they suffered an adverse employment action because of the protected class or trait. Proof of the causal connection is at the heart of the employment claim. Okay, so remember, the thing that we're looking at is the individual's perception, but also there has to be an adverse employment action. There has to be something, they have to be tangibly harmed in some way that is causally connected to their claim of a sexual orientation and gender. So the easy way, obviously, to avoid this is just to ensure that we're not creating a causal connection, right? We're not creating a cause for one of these kind of claims through bad hiring practices, through having a workplace environment that is disrespectful, et cetera, et cetera. Okay, so all of this stuff, again, it ties back to some of the earlier issues, right? Pregnancy. Let's talk about pregnancy very quickly. So you cannot discriminate against pregnancy. Pregnancy cannot affect your hiring decision. Again, the simple thing is you want to get the best candidate for the position, and pregnancy should not factor into your determination. One of the other areas that you also want to take a look at that's important is the Family Medical Leave Act, or FMLA. And in New York State, you have alternatively the New York State Paid Family Leave Act of 2018. I'm going to talk about both of these quickly for a moment, but this is another area where you can run afoul of the law and end up with some kind of a discrimination suit that you don't want, and you don't want to be violating federal and state laws. So FMLA, just briefly, it entitles eligible employees to unpaid job protected leave for specified family and medical reasons, and with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. Now, this is unpaid leave. New York State, in 2018, this year, has passed the New York State Paid Family Leave Law, which is going to be phased in over a 4-year period. It should be fully phased in by 2021. And it's a paid leave for eligible employees. So employees that are working 20 more hours a week would be eligible if they'd worked for at least 26 consecutive weeks preceding the first full day of leave. Employees working less than 20 hours a week should have worked for at least 175 days. I mean, this whole mechanism. I mean, there's a bunch of stuff you can look at on this, but it's actually funded by a draw that comes from the employees themselves. And it's an opportunity to basically create an environment where people, if your mother's dying, God forbid, or you have an issue of that kind of severity, that you have the ability to actually address it with your family. All right. So we want to honor these. So I've kind of gone through this a little bit. Here's a little bit more about the FMLA. But you have this in your slides. I want to keep moving because I want to leave time for questions here. Age discrimination. So here's another broad category, but basically employees over 40, you cannot discriminate against them because of age. So the big thing is even if they're over 40, if they're qualified for position or performed their job satisfactorily, there's an adverse employment action that could be triggered for discriminating against them. And one of the big things you want to look for, or at least courts would look for, is seeing a younger individual getting a job where that younger individual is clearly inferior to the older over 40 individual. Okay. Again, this is maybe, this is equally important as the other ones. It's maybe less obvious, but it's an important protected class. Okay. Now, we're going to talk about avoiding liability here for hiring and management. So this is affirmative defense. Employers can avoid liability for discrimination by demonstrating that the company has policies and procedures in effect to prevent inappropriate workplace conduct from happening. So again, all right, the company code of conduct, the onboarding, the onboard training when you onboard a new employee, the annual trainings. This is why, you know, I'm pushing this so hard, especially the early part of this presentation. But we're really leading up to something so that you have a real defense in court. God forbid you have to defend against one of these suits, which can be crippling. I mean, obviously, I showed you previously some of the numbers that just in the last year alone that we saw from some discrimination lawsuits. Okay, you want to demonstrate that your complainant or the angered or offended employee has failed to utilize company's policies and procedures, and that if they had used those policies and procedures, they had followed your code of conduct, they had followed correctly the lines of reporting to their supervisor to complain about a potential discrimination, et cetera, that they would have avoided some or all of the harm. Okay. Now, again, circling back here, employer compliance. Because again, the big thing is we want to avoid this. We don't want to get to affirmative defense. We want to avoid, in the first place, ever having to put an affirmative defense forward. So just remember, you cannot reject candidates based on a disability or age, which are both protected groups under federal state law. Discriminatory conduct is prohibited in all aspects of employment process, including recruitment. Okay. And you've got to remember, refusing to accommodate an applicant or employee with a disability is discrimination. Okay. Again, reasonable accommodations. I believe, if I remember correctly, there's a slide following shortly. We're going to talk about both of these, but there's a wide range of how this could work out with an individual employee. But if they ask for something because of a disability, please try to provide it for them, and please document that you've provided it for them. All right. You want to document this whole process again, each time. All right. And one of the important things too, here's a little bit of a trap that you want to avoid. Okay. You can't, when you are hiring, even doing the job interviews, you have to create the same experience for the employee. So you can't, you don't want to create a different experience, like meeting someone in an offsite location. You want to have the same experience for all the interviewees. Again, we don't want to have anybody say something's different during their hiring process and it was the result of some kind of discriminatory practice. All right. Okay, here's the slide I've been referencing that I know that's coming up. Okay, so we're going to talk here about the legal definitions of reasonable accommodation and undue hardship. So reasonable accommodation is any modification or adjustment made to the way things are, customarily done in order to enable an individual with disability to perform the essential functions of a job. So a request for reasonable accommodation may be made by an applicant or employee at any point, and you would be wise, to help them. Okay. Now, there is a caveat, right? An action requiring significant difficulty or expense, taking into account factors such as the size of employees, corporation, or organization, or financial resources. So if someone has a ridiculous request, okay, that is going to cost your company a considerable amount of money, and obviously I'm not talking about, you know, small things, but I'm talking about something that is truly an undue hardship on your company, then obviously you can refuse that request. But you again, we want to go through the process. You want to have it all formally done through HR. You want to document this entire thing, especially if you're going to refuse an accommodation request because of undue hardship. All right. And I would actually say, I'd even go farther. I would say that if you're in that kind of a situation, especially if you have a potentially hostile employee, you're going to want to maybe speak with an attorney separately about the exact facts of that situation and get some kind of actual legal advice, because again, you do not want to trigger a disability lawsuit. But so I would actually get an opinion on an undue hardship situation. So retaliation. Here's another thing that you must at all times avoid. Okay, retaliation occurs when an employer takes adverse action against an employee for some protected activity. Okay, and it could be anything from excluding from a project. I mean, there's a wide variety. Now, of course, many employees underperform, and that's a whole separate thing. But again, if that is documented, you should be able to help, you know, defend against a claim for retaliation. But again, you want to try to avoid the appearance of a retaliatory action with your employees. Okay. Now, some protected activities that you've got to be aware of is things like speaking up about or opposing discriminatory practices that the employee believes to be unlawful, or performing adverse actions to keep an employee from undertaking a protected activity. Okay, so again, this is a part of the process that we want to consider. Okay, Protected activities here. So filing a charge for an employment discrimination, cooperating with internal investigation, serving as a witness in an EEOC investigation or litigation. Those are completely protected. I mean, if those occur with one of your employees, you have to comply and work with them and document that you're working with them. Anything else would be very, very foolish to do. Okay. Adverse actions. And I'm sorry, and also here for two reasonable accommodations based on religion or disability. Okay. Adverse actions. Adverse actions are the unjust material impact on an employee's terms or conditions of employment. All right. So again, this is firing, reduction in salary, etc. So the basic concept here is that when a protected activity occurs with employees, which could be a wide range of things, including obviously reasonable accommodation, you cannot take adverse actions against them. You've got to accommodate them. Okay. I think I already discussed covered individuals earlier, so I'll keep moving through these slides. The basic ideas here, I think that my summary here is always hire the best candidate. Cannot decide against promoting or hiring against candidates due to age, race, gender, or any of the other protected discriminatory categories. Do not ask questions regarding categories of discrimination during the hiring process. Okay, make reasonable accommodations as long as the accommodations do not create an undue or unreasonable burden on your company. You want to always avoid unjustified adverse actions and refrain from retaliation. Okay. Now I want to talk. We're moving on towards the end of this because I'm moving very quickly because I'm trying to leave some time for some questions, and we've got about 13 minutes or so left here. So I want to talk very briefly on conflicts of interest. Okay. Now this is actually a common thing. You'll have. And this is why, especially now in what people are calling the gig economy, where employees will be working a second job, they might be freelancing on the side. Now, this is acceptable, it's fine, but there are areas where you can have a conflict of interest. Now, this becomes even much more important when you start getting into things like government contracting and all that kind of stuff. I'm talking a little bit about that, but I'm also talking about how your employees how to help you ensure that they are working for your best interest at all times. Okay, so conflict of interest occurs when a person or organization involved in multiple interests, financial or otherwise, and serves one interest could involve working against the other. Okay, so this relates to situations in which the personal interests of an individual or organization might adversely affect a duty because they have their legal duties owed by employees and managers. Right, they're in their fiduciary duties. They're things that they owe you as your employee. And basically the conflict of interest is when another party they're taking precedence and actually not adequately satisfying the duties owed to you. Okay, and the presence of a conflict of interest is independent of the occurrence of impropriety. Therefore, a conflict of interest can be discovered and voluntarily diffused before any corruption occurs. Okay, so it's not the end of the world if a conflict of interest occurs, but there needs to be mitigation, and it's the kind of thing where it can become increasingly devastating to your company over time. So again, if there's a conflict of interest, it just needs to be addressed. It doesn't necessarily trigger firing, et cetera, et cetera. Okay. So again, it's when an employee has their primary interest, which is to you, especially if you're their full-time employer. Okay. And when a secondary interest supersedes that, which is when this occurs. Okay. So conflict of interest, very often they focus on financial or relationships because they're just easier to see. Okay, but this is especially important when we get to this topic, which is proprietary information. So depending on what your employees do, your conflict of interest may be quite minimal. But if you have individuals that are involved in proprietary information and they're working for other parties, you're now getting into a much more of a slippery slope. Okay, so this is very important. You want to have your proprietary information hermetically sealed, right, from the outside world, unless obviously you have non-disclosure agreements or mechanisms like that to protect you. Okay, so this is intertwined with conflict of interest. Okay, because this is obviously it's very important that your management protects your proprietary information, and obviously there can be issues when you have them working for multiple companies or freelancing or what have you. Okay. Now, all employees have a duty to protect their employer's proprietary information. And proprietary information is commercially valuable information that the employer has developed or obtained and taken reasonable measures to keep confidential. Does not include information generally known or derived from a general training offered by the employer or is readily ascertained by proper means. Proprietary information is kind of its own category. It's between unprotected information, such as trade skills or stuff that you'd find on the internet, just public information, and highly protected trade secrets. So, for example, one of the most famous ones would be the recipe for Coca-Cola, right? Highly protected information. Okay, it's a broad category, and it actually developed from employment contracts. So it's not really something that comes from civil code or state code so much, but it's really something. It's an area of law that just developed over the years from employment contracts. All right. So just moving quickly here, I want to make sure that we have time. So one of the big areas that you're going to want to protect your company is procurement sensitive information. Now, if you are making, you're in the bidding process, so you may be bidding on government grants, you may be bidding on contracts, and obviously it could be government contracts or grants. It could be things from a third party or another company subcontracting, right? Like, so when they put out a bid for subcontractors, and maybe you're going to work with a large prime on a contract. So this is procurement sensitive information. The documents, materials that you develop should be protected. Again, this is why you want to have very clear things with your conflict of interest and also with non-disclosure agreements to help you. Source selection information. But basically, we're looking at your pricing, your proposed costs, all this stuff, your budgets. These things should be kept in-house. They should not be shared or widely circulated. And again, this is the kind of stuff that your employees, they need to know that these documents must be protected. Again, this should be in your code of conduct as well, okay? Personally identifiable information. I'm going to go quickly through here, but there's a general responsibility to protect PII or personally identifiable information when it's tied to data. All right, so this is a whole other area, but it's an important thing for you to consider because you can run into trouble if obviously personal things like social security numbers or obviously medical things, if you work in the medical field, if they come out, that people in the general public can get this information. Absolutely, you have a duty to protect PII as well, and this is certainly enforced in government contracting and just across the board generally. Now, another great example of this is the European Union has just instituted in 2016 the GDPR, the General Data Protection Regulation, which is a whole host of rules surrounding protecting the private information for European citizens. It's a lot. There's a lot to unpack here. I actually recently did this for a client. If you're someone that deals with data coming from the European Union, or you're dealing with citizens from the European Union, you actually are required to follow these rules related to GDPR. And if you have questions about that, it's actually kind of a complex thing. I'm happy to help you. Again, I just recently did this for another client and can certainly help walk you through creating the proper documentation and certainly the proper mechanisms to make sure that that this is not an issue for your company. All right. U.S. government contracting, again, this is a whole other thing. If you're doing government contracting, you've got to respect the PII and you got to have data practices in place that protect personally identifiable information. Okay, so that basically comes to the close of my presentation here. I covered a lot of areas. Again, this was not a deep dive into a specific topic, which is something that I certainly do provide for clients, and I'm happy to do. This was a general kind of an overview of some really key and super important areas that if you haven't considered, I really would strongly advise you to consider for protecting your company. It's very important to make sure that you stay in compliance with federal and state law, and also keep a respectful environment and a long paper trail with your employees to just make sure that you're protected and that you can provide some of those defenses in the event that you have a large lawsuit levied against you. So again, I'm available to talk. I think Elvis hopefully can jump in here and maybe we can field a couple questions. But I do management consulting and business development. Again, I've mentioned I'm a winning grant proposal writer as well. So I'm happy to help walk maybe people that are new to that process through some of those things, and I also do some corporate trainings as well. If any of the areas are areas of concern for you, I would ask you to just reach out to me and connect with me on LinkedIn as well. I'm happy to make your acquaintance and help you however I can. Okay, so thank you so much, and I think maybe we can open the floor the last 10 minutes here or so. Elvis, are you
Thank
there?
you.
All right.
Thank you, Corey. That was a great presentation. We have a question from Pete Frasco. I don't know if you see it in the chat box.
I don't see it in the chat box, so give me 1 second here. My apologies. You know, this is not the most tech savvy person here. So where's the chat box? The Q&A? This it?
Yeah. You see it?
I see. I don't. I do not see it. Maybe you can read it to me, Elvis, and I can try to help.
I'll read it. So Pete Frasco says, from a discrimination standpoint, with an accent, regardless of origin, but non-disability, that has an impact on an individual ability to communicate, fall into inability to perform duties of the job?
That is a great question. That's a great question. So the question is basically this: it is such a strong accent that they are unable to do the essential functions of the job. Well, that's good. That's kind of a gray area. I love that question. So that is a great question. So, I mean, what I would do in a situation like that, because it is a little bit of a gray area, right? So if the accent is so strong, so for example, let's say your employee works at a call center or they're a receptionist, for example, they're answering the phones all day for you, and you're getting constant complaints from your client saying, you know, I just can't understand anything. We set up an appointment. This guy is, I can't, you know. Well, you do have an area where, you know, someone could probably bring a claim. So the thing that I would do in that situation, if I was working with you, is we would obviously want to try to come up with some kind of an accommodation for that person. So I would see if we could do some kind of trainings or have something with the individual to try to see first and foremost if they're aware that this is an issue and if they can correct the issue or try to work with them. The other thing is maybe trying to move them to a job function that is less maybe client focused or whatever the relevant thing is. But if you really have something where someone is failing at their job because they cannot understand the language well enough or speak the language well enough to do the job correctly, what I would do is I would, you know, if you're in that situation, definitely document, and then obviously try to have some kind of a mitigation with them. So again, the basic concept is you are papering your files on this individual before they're dismissed. Now, look, at the bottom line is, if someone can't do their job, I mean, this is not a charity. You're running a business. You can dismiss people. The idea is you want to be in the strongest position you can be, especially for these sensitive areas, and that is a sensitive area. So, thank you for that question. That's a great question.
I will give it 1 more minute to see if anybody has any questions. If not, I would thank you, Corey, very much, and Corey will be available to answer any questions through email. I'll share his PowerPoint slides and information when I send you the recorded link of this session. Also, I just want to remind you that the National Veteran Small Business Week is coming up, and it's going to be the second week of November from 5 to 9. And on November 8th, we're going to have a host panel of veteran-owned businesses who will share their successful tips on business and some do's and don'ts that they experienced. So let's see if anybody has any questions. We'll give it a few more seconds, and if not, it will end the session. So we have a question from, is it legal to ask potential employee to state their gender prior to hiring?
No, I wouldn't do that. I would avoid that.
Okay, so
Okay, well,
we have 1 more question from Tracy. She says, I'm starting a business training service dog. I'm concerned of injuries related to the dog diabetes. Is this just a question of how good is my insurance? what insights can you provide?
So it's a training blog.
She's running a, I'll just copy a question just a second.
Okay, yeah. Well, yeah, obviously you certainly want to have insurance. I mean, the big thing with your training with your dog is you're really looking at really more torts, right? I mean, if someone being bit by your dog or something. So that's not in the realm of discrimination or some of the things we've talked about, but yeah, you obviously would want to have insurance. You want to, you know, make sure that you have the right dogs placed with the right people. So that's really more of a tort question, I think. But yeah, you obviously would want to have insurance for that. So that would be, I think you've kind of answered your own question.
Okay, so thank you, everybody. I don't want to take too much of anyone's time. And like I said, Corey will agree to share his information. I'll make sure I'll send that information in the email with the recorded link that I will send out later today. So you can reach out to Corey personally and ask any other questions that you might have. Thank you, Corey, again.
Thank you so much, everybody. I really appreciate this opportunity to share with you, and please feel free to contact me, and I'm happy to help.
Okay, thank you, everybody, and I'll see you next on our November 8th.